Hello and welcome to an Ocean Australian guide to property law services. My name is Richard and joining me today is Jen, where we'll be talking about the transfer of property ownership titles between siblings.
Hi, my name is Jen, and before we start, it should be noted that when we say sibling, we are following the legal definition, that being a biologically or legally adopted brother or sister currently residing in or have previously resided in the same household or residing or has resided with a child having the same legal guardian. To put it simply, when we say sibling in this case, we mean a brother or sister that was born from the same mother and or father or legally adopted by said individuals. As long as they are or did live in the same household with you under the association of brother or sister, they can be classified as a sibling.
So why might you want to consider transferring property ownership titles with a sibling? Let's talk about a couple of potential risks that you may go through in life that would prompt you to take such a course of action. Firstly, it's important to recognize that your property is classified as one of your greatest assets in the eyes of banking, government, and other third-party entities.
Yes, there may be scenarios where your property may be forfeit to the banks, the government, other third parties, or a combination of all three. Payments such as debt from loans or gambling, payments for lawsuits, and charges for criminal activities are all subject to your personal wealth and assets. Under certain circumstances where you cannot repay lawsuits, debts, or fines you have accumulated, your property may be repossessed and sold.
The same risk can also apply to those who have an insufficiently prepared will. In the event where you suddenly pass away without a prepared will, without clear legal direction, your property may be forfeited to the banks, the government, or another third party.
In both cases, a dispute for the property may be filed. This process can be extremely lengthy and expensive with court appearances, finding and providing documentation, and hiring lawyers. As such, a transfer of property title ownership may be a method to prevent such grievances.
Of course, a transfer of property ownership between siblings can't be done if you don't even own the property in the first place. With the prevalence of scams and electronic manipulation, it is possible that the property you purchased may not currently belong to you. As such, it is crucial that you find out if your name is indeed on the property's ownership title.
Before we conclude, there are a few extra points to consider that you may want to reconsider before proceeding with transferring your property title ownership to a sibling. The first point would be that transferring property ownership between siblings costs money. As a matter of fact, most transfers cost money, with the exception of transferring property ownership between partners.
Another more minor point is that some pensioners may have tax reductions for certain property-related taxes. With that said, this concludes Ocean Australian's guide to transfer of property ownership between siblings. Be sure to keep an eye on this place for more videos on property law-related services.
If you have any further questions, please be sure to send us an email or call us. Thanks for watching.